I'm going to talk a little bit about employment contracts. Now, we've talked about the employment at will doctrine, which means the employee can quit at any time for any reason, and the employer can fire the employee at any time for any reason. And one good way to change that contract rule is to simply write up a different contract. And that can be done orally, and that can be done in writing. Of course, if it's in writing, it's going to be much easier for people to prove at a later date. So some of the things that a person might want in a contract of employment, if you're an employee, is a provision that you can be fired only for some good reason. Sometimes contracts call that just cause. Or the contract might provide a detailed list of grounds for the discharge. Maybe the contract will provide for some sort of a hearing, some statement of reasons. Maybe it will provide for what we call progressive discipline, which means, the first time an employee does something wrong, they get a warning rather than being fired. Or maybe they get a warning and then the next time they get a suspension for a number of days before they're fired. So we don't immediately go to firing the employee. And of course we could provide in the contract for severance pay when the employer and the employee part ways. Now, from the employer's perspective, the employer often wants a non-competition agreement so that when the parties part ways, the employee doesn't immediately go out and start competing against the employer. And in recent times, many states have statutes that limit the employer's ability to put those clauses in contracts, especially for low-wage workers. Employers often want to have in the contract some protection against employees using the employer's trade secrets, customer lists, formulas, and that sort of thing. And there's always the question of whether the parties want to have an arbitration clause in the contract. This would provide that if there's a dispute arising in the future, instead of going to court and having a judge and a jury and all that sort of thing, the dispute would be decided by an arbitrator. And of course, there are pros and cons to having arbitration clauses in employment contracts. There are many other things employment contracts can cover. We just don't have the time here to go through them. You want to check with your local employment lawyer to see what you need in your employment contract. Thanks for watching.